Thank you for inviting me here today. So I'm going to talk about what happens after patient harm. So often we focus on keeping patients safe, that we forget to have conversations about what happens to those patients who do get harmed. So I'm here to have that conversation with you. But first I need to tell you what happened to my father, and then talk about responses to patient harm, how too often tools of power and secrecy are used, and then there's a much better way. This is my father, Elaine Clarkson. The summary of what happened is that he was helping with a controlled grass burn in rural Kansas. He was burned very badly. My mother brought him to a local hospital. The nurses in the emergency room knew he should have been transferred to a burn center immediately, but that's not what happened. The physician on duty wanted to keep him there. He was admitted to the ICU, and it wasn't until the next day that a new physician was able to get him transferred to the burn center. Upon arrival at the burn center, my mother was told that he's going to die. He's not going to make it through the day. He didn't die that day. He managed to hang on for a while. He even had skin graft surgery over his entire back, but he did die 11 days later. And this was a horrible, tragic thing for my family to go through, but that's not really what I want to talk to you about today. We had great concerns about his care. We knew he should have been transferred immediately. That's what the people at the burn center told us. We wanted to go back to the local hospital and talk to them. Did they understand this? How were they going to make sure this didn't happen again? But the local hospital, they refused to talk to us. We tried and tried and tried and tried. We had letters, we tried to have meetings. Finally, in 2014, we made the decision to file a lawsuit. This was the only way we were going to get information. And we had to do it then because Kansas has a 2-year statute of limitations. If we wanted information, this was the only way. So the depositions, which is the testimony, those took place from November 14th to August 2015. And I don't have the time or the emotional capacity to tell you what my family went through during those depositions, but I'm just going to summarize with a little bit of data. After the depositions were all over, I counted the pages. Now, here's pages of depositions from nurses, hospital administrators, physicians, and on and on. But the first depositions were my family. My brother, who lives in California at this point, he gave testimony for 3.5 hours. He wasn't even in the state. My testimony lasted 8 hours. I wasn't even in the state. My mother's testimony, who she had to do alone because my brother and I were not allowed into the room, took 8 hours. Because one thing the defense wanted to establish was that my mother had not asked for a transfer. And no one told her that she couldn't ask for the transfer. Well, of course not. She went to the hospital and we trusted that they knew what they were doing. But that was very important for the defense to establish that. What came out of all of this, I mean, all these hours of my family giving deposition, it got a lot of billable hours for the defense lawyer. And I always wonder if it was somehow trying to punish a family for filing a lawsuit. My mother described the experience as an interrogation, and I agree. So, but these depositions, once my family went first, once we gave our testimony, then we started to get some information. Finally, for the first time, it took over 2 years, we began to get some information. From the physicians, the nurses, the expert witnesses, little bits of information started coming through, and we were horrified at what we learned, because that delay in transfer, that was just one of many, many medical errors. And so, In October 2015, I can't tell you what happened after that. I just have to use the phrase, the matter has been resolved. So that's my family story, and I want to give you the summary. This was 3.5 years, a tremendous, lawsuits are very expensive. Those defense lawyers rack up a lot of billable hours. The financial cost, the emotional cost, the time and effort. I was a PhD student at the time this happened, and I know this delayed my graduation by at least 6 months, probably more. And this happened because of power and secrecy. This happened because of the toolbox of power and secrecy. And that's what I want to talk to you about today, is that our healthcare culture is immersed in this toolbox of power and secrecy. And because you're inside of it, you may not even realize it. So I'm going to go through some of the tools in this toolbox. First one is non-disclosure agreements. So you notice my story came to an abrupt end. It's because my family signed a document. This is part of the document. I've blocked out the interesting parts, but I've highlighted one that says, if asked how the case was concluded, they shall respond by saying that the matter has been resolved. This makes it awkward to have some conversations with people, but this is what I have to uphold. And non-disclosure agreements are really, really common. There's one paper that looked at these agreements in the University of Texas system. They looked at 5 years of non-disclosure agreements spanning 2001 to 2012, I believe. They picked some years in there. And of the 124 settlement agreements, 110 had non-disclosure agreements, and here's what was in them. 100% said the family patient cannot talk about the term settlements or the amount. 56% can't say the S word. 46% cannot even say what happened medically. 26% prohibit reporting to a regulatory agency, and 3% disparaging the physician or hospital. Now, once the authors of this paper let the University of Texas system know about this, they write in their paper that the University of Texas system no longer prohibits the reporting to regulatory agencies as part of their disclosure agreements. Non-disclosure agreements, how much of our healthcare system is propped up by these? I don't know, and no one does, because we don't talk about this because we can't. The next tool in this toolbox of power and secrecy is the confidentiality of investigations and reporting. My family tried everything we could to talk to that local hospital. We wrote letters, we tried to set up meetings. We got a letter that had this paragraph in it. As it pertains to sharing information about our risk management activities, including reportable incidents and the name of the physician, and this Kansas statute specifically precludes us from disclosing information with outside parties. This is false. What this statute says is that when a hospital does an internal investigation, the records they produce, if the case goes to court, the other side cannot say you have to give us those records. In other words, those can be kept confidential. It doesn't say you can't make the choice to share it with patients and families, but this is this hospital's position. They use this to insist they could not talk to us. We also tried to go above the hospital, find someone else who would be accountable. We reported this to Medicare. So Kansas has an organization that contracts to investigate Medicare cases. They got back to us within 3 months with this. This was great. We learned something. We determined that some of the care your husband received did not meet professionally recognized standards of care. This was the first piece of information we got. So our questions were, okay, what was it and what are they going to do about it? That's not for us to know. We don't get to know. Kansas Board of Healing Arts is the Accreditation Board for Kansas physicians. We also filed a complaint with them. Every few months, my mother would get a letter saying, we're still not finished, we're still on it, we're continuing, we're still on it. But a year later, we got a letter with this statement. Based upon the disciplinary panel's review of evidence in the investigation and a thorough legal analysis, public disciplinary action was not authorized, which means you don't get to know anything. So everyone else got to investigate and learn what happened to my father, but my family, we didn't. None of that was shared with us. The next tool in this toolbox of power and secrecy, state statutes concerning malpractice cases. Here's three major ones. Now, as I said, statute of limitations. We had just 2 years. We had just 2 years to realize that we've got to file a lawsuit now or there's no hope. This next one, the second one, caps on damages that the patient and family can collect. This, Kansas does have this. The effect is that it removes the ability of injured patients to use the civil justice system. Lawsuits are very expensive. The lawyers who take this, it's a business. They need to be able to make a living from doing this. Patients have to have a clear harm, clear negligent, and the negligency needs to cause the harm. And there needs to be enough money online to make it worth their time and effort and for the vast majority of patients, they just don't have a strong enough financial case, even if they have an extremely solid malpractice case. Now, one that we did not encounter in Kansas, but affects people in other states, are these pre-trial screening panels. I've never seen a legitimate explanation for this, because from number 2, a lawyer will never take a case unless it's really solid and there's a lot of money on the line. But some states have enacted panels of physicians that you don't get to file a malpractice case unless they agree that you should be allowed to. Other state laws. Apology protection laws are very common. What these laws do is they say, if we're talking to a patient family, we've given them information, an apology, that information that cannot be used in a lawsuit against that physician or that hospital. And in general, I agree with these statutes. I don't have a problem with them. The problem is they don't actually require anything be done. The laws that require something to be done, this mandatory disclosure, those laws are rare and they are very weak. A few states have them, but they are worded very, very weakly. And my mother and I tried for 3-4 years to get mandatory disclosure of medical errors in Kansas. And this was a piece of the testimony that I gave, because the reality is when you enter a hospital, you have no right to know what has happened to your body. And my argument was, if you're not going to be honest with what has happened to me after harm, let's make hospitals be honest before harm. When patients walk in the door, post this sign saying that patients do not have the right to know about unanticipated medical outcomes. They don't have the right to know about harmful errors. Tell patients up front, because I think most would be shocked that this is the state of our legal system. Sometimes professional healthcare societies put themselves in the toolbox of power and secrecy. That's the Kansas Medical Society. That's the Physicians Association of Kansas. They have a political action committee, and the goal to make it the best state in the nation to practice medicine. I'd like to point out there is no political action committee for patients to make it the best place to be a patient, but the physicians have a political action committee, which is fine. They can represent their own interests, but where's the patient representation? Well, where's the patient representation? Sometimes the societies want to speak for patients. I encountered this is just one example, but I've encountered this again and again and again. Physicians in hospitals represent themselves as speaking for patients, and here under their advocacy on CAMCO. CAMCO is a big malpractice insurer in Kansas. State, unrelenting efforts to champion the cause of healthcare professionals and the patients they serve. I want to see patients championing patients. I'm not sure I trust a malpractice insurer to do that. So to help you put some of these pieces together, I'm going to explain how they affected my family. After my father died, this is my mother, my brother, and me. We filed a lawsuit. We got a lawyer first, who then named who was to be filed in the lawsuit. And because you can't add people later if you get more information, you have to name everyone up front. So this was 3 physicians in a hospital. All of them were insured through CAMCO. That means that CAMCO chose the lawyers to represent each of them. So we filed our case, the depositions are going on, so the lawyers are working through this. But I want to make the point that CAMCO chose these lawyers, so surely CAMCO approves of how the lawyers behaved in the deposition, or else they wouldn't have chosen these lawyers. They must have approved of having my mother give 8 hours of testimony, or else they wouldn't have chosen lawyers who do that. But here's the thing about CAMCO. It is a company of the Kansas Medical Society. And I've already told you that the Kansas Medical Society lobbies the state for laws favorable to physicians, as well as the Kansas Hospital Association. Interestingly, the Kansas Medical Society and the Kansas Hospital Association have formed a group called the Kansas Healthcare Collaborative. Now, this is a nonprofit organization that focuses on safety, and I am all about safety, and I will do anything that I can to support the Kansas Healthcare Collaborative. But it really raises a question in my mind when the parent organizations of the safety organization is the same organization that approved of how my family was treated in our depositions. And so when the Kansas Healthcare Collaborative talks about being patient-centered and they talk about being transparent, it doesn't sit well with me because I know how these connections work. Finally, my last tool in this toolbox of power and secrecy is this term risk management, which I had never heard this term before my father was injured. I had no idea what it meant. My assumption was this was managing health risks to patients. I thought this was about keeping patients safe and making sure that they're getting the appropriate medical procedures that have the best chance of having the best outcome. That's what I thought risk management was. And then I realized that's the name of the office that said we're looking out for our own money. I'm like, so when patients are injured, the office they're sent to deal with is the office that says we're looking out for our own money. And I'm like, oh my God, this was just really hard for me to wrap my head around. And I'm not in the healthcare field, but I've come to realize that much of the physician behavior after patient harm is driven by what those in the risk management office say. And much of what what those in the risk management office say tends to be driven by their insurance company. So there seems to be a chain of command or some type of connection there that is, I think belongs in this toolbox of power and secrecy. Okay, so I want to close that toolbox and wrap up, I have 4 more minutes, with thinking about, okay, what do patients want? Here it is. Patients want a timely explanation of what happened and why. They want consequences mitigated. If they need more treatment procedures, make sure they get it and don't charge them for it. In fact, don't charge them for the original procedure where they were injured. If they've suffered, financial compensation is absolutely appropriate. They also want institutional changes to prevent it from happening in the future. They want institutions to take this seriously, and that means digging into it and making sure it doesn't happen again. And when appropriate, this is substandard care, they want an apology. So, as you can see, what patients want and that toolbox of power and secrecy have nothing in common, and that's why there is another toolbox I want to tell you about. Communication and resolution programs are a principled and systematic way to deal with patient harm. Now, those of us who are on the patient side, we don't necessarily like the word resolution because that's a legal term, so we would prefer they be called reconciliation programs, which doesn't actually mess up the acronym, so I'm all for that. Okay, I'm going to step you through what these are about. Here's the core commitment. So if you're a hospital, what's a CRP? Here's what you have to do. Be transparent with patients and families about what happened and why. Again, it's not that you're holding the power, it's baked into the system, transparency. Second, analyze the diverse events, figure out what happened and how to prevent it. 3 is support emotional needs of everyone, the patient, the family, and also care for the caregiver programs. I understand medical harm, medical errors deeply affect physicians, nurses, anyone involved. Support programs for everyone. And then, yes, if care is unreasonable, offer compensation. Not as a risk management strategy to get them out of your office, but as coming from a place of honesty and integrity. Here's a big one. Educate them about their right to seek legal representation. Work collaboratively. Patients are transferred between facilities. There may be an incident that spans multiple facilities. Everyone needs to be involved. And continuously assess the effectiveness. I don't have time to give you any more details. That is a whole nother talk. But Steve is here, and he is also involved in this Collaborative for Accountability and Improvement. And so please, if you have any questions, that's where I want to send you to, and I know I'm out of time. So these are the two toolboxes. Healthcare system has lived its life in this one. There is another way. But so I am optimistic a little bit. I'm also extraordinarily skeptical that because healthcare systems have grown up in the box of secrecy and power, and people have been trained in the secrecy of power, I am very skeptical that there can, anytime in the near future, be a shift. But these are the 3 groups that need to be on board. The first is insurance companies, because if a hospital wants to do this, their insurance company has to be on board. Nurses, I think, are an extremely underutilized resource, and I think they can be the ethical and moral integrity of the organization that pushing towards a CRP model. And students, people who have not been indoctrinated into the box of power and secrecy, if they're introduced into this alternative way, that's my real hope, is that in the future, future generations will see a different path forward. That is my contact information. I know I'm out of time, so thank you.